Hello, everyone. Happy New Year. Hope you're having a wonderful, safe, and happy holiday week. Today's episode is just a short check-in with the cases you've been following closely so that you can get back to enjoying time with your loved ones during the holidays. We are recording this on January 2nd, 2025. Let's jump right in. The AP is reporting that an Argentine judge confirmed charges against 5 people in connection with the death of Liam Payne, a former member of the musical group One Direction, and ordered preventative prison for 2 of them for having supplied him with drugs. One of the 2 people ordered to be put under preventative prison, a form of pretrial detention, was an employee of the hotel in Buenos Aires where Payne stayed until he died after falling from the balcony of his room in October. The other person was a waiter Payne met in a restaurant. The judge also charged 3 other people with manslaughter, including a businessman who was with Payne in Argentina and the 2 managers of the hotel. Payne fell from his room's balcony on the 3rd floor of his hotel in the upscale neighborhood of Palermo in the capital. His autopsy said he died from multiple injuries and external bleeding. Toxicology exams showed that his body had traces of alcohol, cocaine, and a prescribed antidepressant in the moments before his death. Payne's autopsy showed his injuries were caused neither by self-harm nor by physical intervention of others, but that Payne did not have the reflex of protecting himself in the fall, suggesting he might have been unconscious. All right, well, what is happening here? This case is tragic, but it also raises some very interesting questions about criminal liability. And I get it, granted, we're dealing with another country. It's got its own unique views on liability and evidence and crimes and everything else. But at this point, or at what point, does the supplier of drugs, narcotics, even illegal narcotics, maintain responsibility? Remember, there's no allegations here of him being pushed. There's no allegations that he overdosed. That's not what killed him. The fall, obviously, is what took his life. So, as far as we know, he was supplied drugs, and this is, again, going off of the information that we have in hand right now, but he was supplied drugs which caused him to be unable to care for himself. Think about this. He simply, same conduct on the part of everyone involved. He could have taken those drugs, he could have passed out, and harmlessly slept it off, but he didn't. He took those drugs, same conduct of everyone else. He fell. It was unintentional on his part. It was unintentional on anyone else's part. It was tragic. But is it criminal? If the crime here is beyond the furnishing of the drugs, then what is the conduct? I mean, it's not being alleged that it was a hot batch of drugs, that these drugs somehow had something in them that he didn't intend to take, unless there's something we don't know. And again, we're dealing with the information that we have in hand. But where does the crime arise for those individuals involved, the people who may have put him in connection with drug dealers, the hotel people who may have seen him under the influence? If they're not being held responsible for an overdose or for pushing him over that ledge, then this is a tragic accident. And I am having trouble connecting the dots, but maybe you guys can. What do you think? If I'm missing something, please let me know in the comments. Moving on, a young woman serving a possible life sentence for murdering her mother with a frying pan and knife won her appeal and will get a new trial, according to reports from Court TV. Sydney Powell was convicted in 2023 of murder for killing her mother, Brenda Powell, at her home. Sydney was 19 at the time of the murder and had been kicked out of school. She killed her mother while Brenda was on the phone with school officials. Sydney was sentenced to 15 years to life in September of 2023. At trial, Sydney admitted to killing her mother, but argued that she was having a mental health crisis at the time. Several doctors testified on her behalf, saying that she suffered from multiple mental illnesses, including anxiety, borderline personality disorder, and schizoaffective disorder. The jury rejected the argument and found her guilty on all counts. At the close of the state's rebuttal case, the defense made a request to call additional expert witnesses, but the judge denied the motion, saying there had been, quote, Lots and lots and lots of expert testimony in this matter. While the prosecution argued that there is no absolute right to a surrebuttal, the appeals court found that Sidney had a right to deliver one in this case. A spokesperson for the state said, quote, "The prosecutor's office is aware of the Ninth District's decision, which only addresses the trial court's procedure and not the defendant's guilt," adding, "We are currently considering options on how to proceed." What's happening here? Sidney's defense of insanity is considered what we call an affirmative defense in Ohio, where this took place. Affirmative defenses mean that the burden is on the defense to prove that she was insane at the time of the murder. It's not a defense of you don't have enough evidence and it's not beyond a reasonable doubt. It's not a defense of I have an alibi and I wasn't there. It's a defense of an affirmative defense saying we want to prove to the jurors an alternative to all of this. And when doing so, in affirmative defense type situations, the burden shifts is what we call it. Now, it's not a complete shift. It doesn't go from beyond a reasonable doubt on the prosecution to now beyond a reasonable doubt on the defense. Usually it's some lesser degree of that. But still, the defense has to prove something to the jurors, which they never do before this type of situation arises. We know that that is a cornerstone of our criminal justice system, that the burden rests squarely on the prosecution. And while defendants are never required to present evidence to prove their innocence, they must prove insanity if that is their argument in court, which was in this case. So with that line of thinking, the appeals court found that the surrebuttal, meaning usually the way it proceeds is you have prosecution case in chief, defense case, prosecution rebuttal. They have the burden, they get the rebuttal. A surrebuttal would follow that, being the defense's answer to the prosecution's rebuttal case. So the Court of Appeals here found that the surrebuttal was in fact a rebuttal case for the defense's case in chief, being their first bite at the apple when they tried to prove insanity, and which they do have an absolute and unconditional right to present. This is fascinating, but it's also very likely precedent setting. Insanity defenses are just one of many affirmative defenses. Consider self-defense, probably the most common type of affirmative defense that we see. This also shifts the burden. And in cases, or the question should be, will in cases alleging self-defense, will they also now be granted by right a surrebuttal case to the defense, at least in Ohio? It certainly seems so. One other note on this case, though, and this is something that really grinds my gears. This all could have been avoided by the judge by simply allowing the defense to put on that their witness, their expert witness in a surrebuttal to begin with. The judge had that discretion and chose not to use it. Lots and lots of evidence is not a legal argument. I'm sorry, but the judge just saying, I feel like we've all heard enough is not a legal argument. And it's not certainly what a judge should be basing their decision on. A judge shouldn't be deciding for the jurors, or for the defense for that matter, when is enough enough. Now, I realize that judges do that many times. They do have discretion to cut things short. They do have discretion to say, I'm not allowing wild goose chases and, red herrings to take place in my trial. But in a case like this, where the prosecution presented some question in their rebuttal case that needed to be answered by the defense, it seems like the easier path, maybe not at the time, but the easier path in the long run would have been just to allow them to call that witness. Then we wouldn't be in this position. And we wouldn't be talking about a retrial. And that is why, and I see this question arise quite often when people criticize judges. That is why you see judges often to defer to the defense. It's not because they're quote unquote defense friendly. It's because they are trying to preserve their case on appeal. They're trying to avoid a retrial. They're trying to avoid this exact situation. But what do you guys think? Do you think the judge messed up? Do you think I'm being too hard on the judge? Or do you think that the appellate court got it wrong? Please let us know in the comments. An Alabama woman who says she was raped by Jay-Z and Sean Diddy Combs when she was just 13 can proceed anonymously for now in her lawsuit against the rap moguls, a judge ruled Thursday, according to the AP. In her written order, Judge Annalisa Torres also chastised Alex Spiro, the lawyer representing Jay-Z, for what she described as his combative motions and, quote, inflammatory language against the plaintiff's lawyer, Tony Busby, calling them inappropriate. The Manhattan jurist said the woman can proceed anonymously at this early stage of the litigation, but she may be required to reveal her identity at a later date if the case proceeds. That would allow defense lawyers to collect facts necessary to prepare for trial. Torres also cited substantial interest from the public. Referring to Jay-Z by his legal last name, the judge added, quote, Carter's lawyers' relentlessly filing of combative motions containing inflammatory language and ad hominem attacks is inappropriate, a waste of judicial resources, and a tactic unlikely to benefit his client. The court will not fast-track the judicial process merely because counsel demands it. What is happening here? Ouch. Judges, you got to understand, I've got years of experience doing this. Judges are usually very reserved in their comments, even when they're heated, but especially when those comments are put in writing, and especially in a case that's being very closely watched across the country. They're very reserved. So when a judge goes as far as this judge did to make these comments, that's the equivalent of an outright smackdown. But I also think it demonstrates something about how this case has been handled by Jay-Z and his team from the onset. They have been extremely aggressive. They have been accusing the plaintiff's attorney of extortion, demanding to reveal the identity of the accuser. Aggressive use in media with these press conferences and making statements. And it's all obviously on purpose. If they felt, this is my point, if they felt it would be more effective, they would have done the typical deny and disappear type tactic that we've seen out of celebrities in the past when they're accused of these types of horrible things. Deny it ever took place and then just kind of take a step back into the shadows. And you don't hear from that celebrity and their social media goes silent. And just wait for the storm to blow over. That's not what they did in this case. And this isn't about the strength of the case or the indignation of Jay-Z. I don't think so at all. He's worth far too much money, has far too many people in his ear. This is about tactics, and they feel that this is a better strategy to employ. Loud, angry, upfront, on the attack. And it makes you wonder if in this post-Diddy world, maybe that's what celebrities think will be most effective. And maybe they are right. After all, if you or I were accused of something this horrific that we did not do, we would probably be irate about it too. So I wonder if that's a switch that we're going to see from other people who might be swept up in this whole Sean Diddy Combs mess moving forward. But what do you guys think? Is there something to the Jay-Z allegations, or is this all just a money grab? Please let us know in the comments. Before I get into the cases that are also making headlines this last week, I'm asking you guys to please take a moment and subscribe to this channel. It is what can help us most, more than anything, in growing this channel, which is what we want to do to continue to provide you all with more content moving forward. And if you don't already know, Courtroom Confidential is also a podcast, so please check us out on all of your major podcast platforms. Also making headlines this week, the man accused of burning a sleeping woman to death inside a New York City subway train has been indicted on murder and arson charges, prosecutors announced last Friday as authorities continue working to identify the victim. SebastianZepeda, who federal immigration officials said is a Guatemalan citizen who entered the U.S. illegally, was taken into custody last Sunday. According to ABC News, Brian Friedman, a lawyer representing 24 relatives who support the immediate release of Eric and Lyle Menendez, intends to petition the Los Angeles Superior Court to transfer the case to the California Attorney General's office. Friedman claims there's a conflict of interest between Nathan Hochman, LA's new district attorney, and Kathleen Cady, a close ally and prominent booster of Hochman, who was recently named the DA's director of the Bureau of Victim Services. Previously, Cady served as the attorney for Milton Anderson, the brother of Kitty Menendez, who pushed for the continued incarceration of Eric and Lyle Menendez. A man who kidnapped and sexually assaulted a Northern California woman in what became widely known as the Gone Girl kidnapping has been charged with 2 15-year-old home invasion sexual assaults, prosecutors announced Monday, according to the AP. Prosecutors alleged that MatthewMuller, age 47, broke into a woman's home in Mountain View, California in September of 2009, attacked her, tied her up, and made her drink medications. He then told the woman in her 30s that he was going to rape her, but she convinced him not to, prosecutors said. Muller left after recommending the woman get a dog. Muller was previously charged and convicted in an infamous case that is the subject of the Netflix documentary American Nightmare. 2025 is taking no time to get warmed up because we have a lot of big cases in court next week. This is what's on the docket. ShannaGardner and her estranged husband, Mario Fernandez, accused of plotting to have Gardner's ex-husband, Microsoft executive Jared Bredigan, killed in 2022, will be back in court on January 6 for a pretrial hearing. Gardner and Fernandez could potentially face the death penalty if convicted. Arguments on whether a dog bite expert should be allowed to testify at KarenRead's upcoming murder retrial will resume with questioning of defense expert Dr. Marie Russell on January 7th. The defense has argued that O'Keefe could have been attacked by a German Shepherd belonging to the Albert family. Reed's boyfriend at the time, Boston police officer John O'Keefe, was found dead outside of the Albert family home. A motion here regarding DNA testing in the prosecution of Massachusetts man BrianWalsh has been scheduled for January 8th of 2025. Walsh is accused of killing his wife and dismembering her body. Anna Walsh, a mother of 3 young children and a real estate professional who worked in Washington, D.C., disappeared on New Year's Day 2023 and was reported missing a few days later. Her body was never recovered. JenniferCrumbley, convicted of 4 counts of involuntary manslaughter for the deaths caused by her son, Ethan Crumbley, during the Oxford High School mass shooting on November 30th of 2021, will be back in court on January 8th. Jennifer is appealing her conviction on the ground that the prosecution failed to turn over key pieces of evidence during her trial last year. The Highland Park July 4th parade shooting suspect, RobertCrimo III, will be back in court on January 9th for continued evidentiary hearings. Crimo is facing 7 counts of first-degree murder and dozens of other charges related to the 2022 mass shooting. And finally, LoriVallow, the so-called doomsday mom who was found guilty of the deaths of her children in Idaho and recently permitted to represent herself in a separate murder case in Arizona, will be back in court on January 10th. Vallow is charged in the fatal shooting of her 4th husband, Charles Vallow, and the attempted murder of her niece's ex-husband, Brandon Boudreaux. And finally, we have a Monday premiere coming up. We are going to be doing our 2024 Year in Review Roundup. We're talking about the most important, the most shocking, the most intriguing moments and trials from the last year, and we're going to break them all down for you. So please check that out this coming Monday at 5 p.m. Pacific, 8 p.m. Eastern. We would love to see you in the chat. That is it for us this week, folks. I am your host, Joshua Ritter. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. Thank you again for joining me. Have a very happy new year. Have a great weekend, and I will see you again next week for another episode of Courtroom Confidential.